3, 2, 1, ready, start. It is relevant to state that after the hearing was concluded, the learned counsel for the parties had brought to notice of this court, a decision of the apex court in Urmila Dikshit versus Sunil Saran Dikshit and others 2025 SCC 787, wherein the apex court held as under. The preamble of the Act states that it is intended towards more effective provisions for maintenance and welfare of parents and senior citizens, guaranteed and recognized under the Constitution. Therefore, it is apparent, that the Act is a beneficial piece of legislation, aimed at securing the rights of senior citizens, in view of the challenges faced by them. It is in this backdrop that the Act must be interpreted and a construction that advances the remedies of the Act must be adopted. The appellant has submitted before us that such an undertaking stands grossly unfulfilled, and in her petition under section 23, it has been averred that there is a breakdown of peaceful relations inter se the parties. In such a situation, the two conditions mentioned in Sudesh Chikara versus Ramti Devi, must be appropriately interpreted to further the beneficial nature of the legislation and not strictly which would render oppose the intent of the legislature. Therefore, the single judge of the High Court and the tribunals below had rightly held the gift deed to be cancelled, since the conditions for the well-being of the senior citizens were not complied with. We are unable to agree with the view taken by the division bench, because it takes a strict view of a beneficial legislation. Before parting with the case at hand, we must clarify the observations made wide the impugned order qua the competency of the tribunal to hand over possession of the property. In S. Vanitha, this court observed that tribunals under the Act may order eviction if it is necessary and expedient to ensure the protection of the senior citizen. Therefore, it cannot be said that the tribunals constituted under the Act, while exercising jurisdiction under section 23, cannot order possession to be transferred. This would defeat the purpose and object of the Act, which is to provide speedy, simple and inexpensive remedies for the elderly. Another observation of the High Court that must be clarified, is section 23 being a stand-alone provision of the Act. In our considered view, the relief available to senior citizens under section 23 is intrinsically linked with the statement of objects and reasons of the act, that elderly citizens of our country, in some cases, are not being looked after. Stop. It is directly in furtherance of the objectives of the Act and empowers senior citizens to secure their rights promptly when they transfer a property subject to the conditions of being maintained by the transferee. Stop. In view of the above, the impugned judgment and order with the particulars as described in para 1 of the judgment, is set aside. Stop. Consequently, the gift deed dated 7 September 2019 is quashed. Stop. In the attending facts and circumstances of this case, the appeal is allowed. Stop. Possession of the premises shall be restored to the appellant by 28/2/2025. Stop. Apparently, in Urmila Dikshit (Supra) the apex court made the above observations in context of Section 23 of the Act, as in the said case, the issue of cancellation of a gift deed was involved along with its consequences. Stop. This has been noticed by this court while dealing with issue number 3 in the later part of the opinion. Stop. Para. Then, another decision of the apex court was rendered in the case of Santola Devi versus State of UP 2025 SCC Online SC 669, which throws some light on the subject and was noticed by this court, wherein it was held as under the Senior Citizens Act wide Chapter number 2 provides for maintenance of parents and senior citizens. It, inter alia, provides a senior citizen or a parent who is unable to maintain himself from his own earning or the property owned by him shall be entitled to make an application against his parent or grandparent or against one or more of his children (not a minor) or where the senior citizen is issueless against specified relatives to fulfill his needs to enable him to lead a normal life. Stop. The tribunal constituted under the Act on such an application may provide for the monthly allowance for the maintenance and expenses, and in the event they fail to comply with the order, the tribunal may, for breach of the order, issue a warrant for levying fines and may sentence such person to imprisonment for a term which may extend to 1 month or until payment is made, whichever is earlier. The provisions of the Senior Citizens Act nowhere specifically provides for drawing proceedings for eviction of persons from any premises owned or belonging to such a senior person.